Good afternoon, everyone, and welcome to the second in our 2022-23 series of Planning Live webinars. My name is Victoria Lane, and I'm an associate in the Brodie's planning team. Last month, we heard from Tom Winter and Carrie Thompson about some of the planning reforms which came into force at the start of this month. I am delighted to be joined this afternoon, though, by Elaine Farquharson-Black, one of our planning partners, and Scott Ferrie, the Chief Reporter at DP. Before we'll be familiar with the format. It's an informal chat about planning topics, and today's topic is planning appeals. Planning and Environmental Appeals, DP, which is a division of the Scottish Government's Legal Directorate, considers and makes decisions and recommendations on a range of planning and environmental matters on behalf of the Scottish ministers. Last year, in 2021 to 22, they dealt with 577 cases, covering everything from advertisements and animals to windows and wind farms, and pretty much every letter of the alphabet in between. Heading up the DP team is Scott Ferrie, who was appointed as Chief Reporter in July this year. Prior to becoming a reporter in 2007, Scott held a number of positions in various development management roles in various planning authorities. He then became Assistant Chief Reporter in 2016 before becoming the Interim Chief Reporter in 2020 when Paul Coquette, the then Chief Reporter, was redeployed to COVID work during the pandemic. Now, there is always an element of mystique about reporters, so we are delighted that Scott is here today to give an insight into the work carried out by DP and his priorities for the coming year. And so I'm going to hand over to Elaine, who is going to ask some of those questions which everyone has always wanted to know but has been too scared to ask. Thanks, Elaine.
Thanks, Victoria. I did promise Scott that I wasn't going to be no case-specific questions, so there are going to be kind of general questions, but I might slip in a couple of there that I would want to know. But just thinking about that, you know, Victoria's intro, 577 cases. That's quite a caseload. How big a team of reporters, you know, do you have, and how many cases are they juggling at one time? I think people always think it's my appeal. That's the most important thing. But I mean, that's quite a caseload. So how many people have you got, you know, working on those?
Yeah, sure. First of all, just I laughed when mystique was mentioned there at the start. There's nothing mysterious about me or my colleagues, I can guarantee that. So yeah, sort of taking part in sessions like this, I hope will help to break down any mystique if that exists. On your question, yeah, it is a huge caseload, and within those numbers are some really significant cases as well. So in terms of resources, we've got 27 salaried reporters, so they're civil servants employed by Scottish ministers. We've got 17 self-employed reporters to top up that cohort. So they're like contractors, if you like. They're not employed by us, but we recruit to the self-employed panel every now and again. And that recruitment exercise is just as stringent as it would be if we were recruiting for salaried reporters. So, you know, to the outside world, there wouldn't really be any difference between salaried and self-employed reporters. Just internally, they're not employees, that we don't line manage them, and so there are slightly different arrangements there. And on top of the reporters, we shouldn't forget that we've got 17 caseworkers who do just sterling work in our office in Falkirk and at home now, because they're working in a hybrid pattern. Those, other than a hearing or inquiry or site inspection, those caseworkers are our public face, if you like. And often know more about how a case should work than the appointed reporter, actually. So yeah, they keep us right in terms of procedure.
Yeah, no, they are great. Yes, you can, generally, and those are the ones. It's funny. I was going to come to kind of questions about, if you're wanting to speak to, to ask a reporter where chase up a decision, it's often that kind of gentle email actually to the case officer saying, have you heard anything? What's it kind of going to be? That's a huge number actually. Is that the largest number of reporters that we would have had? There shouldn't, I mean, back in the day, when we did inquiries and things, was there that many?
Yeah, it can't be far off it. We've and I'll come on to budgets later probably in our chat and just mention what's happening generally with that. But we've over time we've been trying to shift some of our resource out of the self-employed cohort and into the salaried cohort because we've got more control, if you like, over the types of cases and the volumes of cases that the salaried cohort will be able to take. Yeah, it must be there or thereabouts. So some of those, first of all, not all of those salaried reporters work a full-time week, because in times of flexible working, which wouldn't have applied 10 years or so ago, everyone would have been working full-time then. So yeah, we've got a whole range of people in different working patterns, so not all full-time. Similarly with the self-employed, some work pretty much full-time for us if that's what suits them. Others might only offer us up 3 or 4 days a month, something like that. So those numbers can be a bit misleading just at that level. That they're all working at different
Yes.
Different commitments.
Yeah, and so they obviously have to juggle more than one appeal at the same time. Presumably, if they're I was going to say, if you're away at an inquiry, do you get to devote everything to that particular one, or you still got the other ones bubbling in the background?
Not always. So if you take on an inquiry case, a Section 36 wind farm case or a big LDP examination, we would always try at the most time-consuming and crucial parts of those cases. We would try to allow the reporter just to concentrate on that case. It's not always possible. Even in those cases, reporters will be trying to finish off other casework whilst the new case comes in and they get that kicked off. So there's juggling going on at the beginning of big cases like that. Sometimes there are dead periods in cases, so you might have a PEM and then have 2 months until the inquiry. So, sadly, work is funneled in at that stage as well. And similarly, when you're coming out of a big case, and typically you'll have spent 3 or 4 months in writing up a report, there's always a bit of optimism bias in how long that's going to take, isn't there? So we work in a system of monthly progress returns. So at the end of each month, every reporter will send a return into the office, just updating on progress in each case and predicting when each case will be finished. And for the following 6 months, flagging up how many free days that'll leave them. So you're working on a report case, it's taking a bit longer than you might have hoped and predicted, but because your monthly return 2 or 3 months before has said, yeah, I should have 6 days that month, work starts being funneled over to the reporter at that stage. So at the end of the process, there's that balancing exercise going on as well, trying to finish off your big report case, but other cases are coming your way at that stage. Obviously, there's flexibility, and if a reporter gets into trouble trying to finish off a big case, they can say, "Stop! Please don't give me any more this month, just till I get this away."
And I know you've got different deadlines for different types of appeals in terms of getting the decision done, and we all look at the portal. We all look at the portal and check, what's the date that my appeal's meant to be. I suppose into questions following on from what you said there, does that date get changed if a reporter comes back and says, actually, I'm behind the time, or does that just stay as the 26 weeks or whatever?
Yeah, that date would stay the same because it's a target date. That date would only change actually if the case goes into cyst. So if we hit a dead period where further environmental information is being prepared or something like that, that would push the target date back. But other than that, no, the target date stays the same. We've started trying to give a bit more information on our website in the case overview section on the front page for each case, where we'll try and give an indication certainly of what stage the case is at, and in some occasions we'll try and give an indication of likely timescales. It's good to be open about these things, and as you mentioned, our caseworkers a little earlier, it saves them phone calls asking questions like that if we can just be open about that sort of information on our website.
And are there steps that you've been taking, or that you have to take, to try to meet those kind of deadlines, the kind of efficiencies? And I suppose a kind of question of looking at from the opposite side, are there things that appellants and planning authorities could be doing to help and to speed things up?
Yeah, absolutely. It takes everyone to conclude a case successfully, doesn't it? So you're just thinking about that question. We've got the ministerial targets for appeals regulations cases. Everyone knows what they are. 12 weeks for site inspection cases, 20 weeks for further and submission cases, and so on. Those are our only sort of formal ministerial targets. We've got the expectation set out in the development planning circular that an LDP examination should typically be 6 to 9 months. So we sort of use that as our target for that type of work. Other cases, we've never had ministerial targets. Section 36 casework's a prime example of that. So we did some work looking at that with the Energy Consents Unit and stakeholders actually last year, and we published Guidance Note 23, I think it is, which talks about a 50-week target for Section 36 casework, and that's a huge foreshortening of how long typically it would have been taking us on that type of casework. I think our average was up maybe 18 months to 2 years. So we're really looking to significantly drive down how long we take with that type of casework. And to do that, we've got milestones in place. You should aim to have your PEM by week X, and you should aim to be going into inquiry by week Y, and setting it all down so that, in big cases like this, there can sometimes be a bit of drift, especially if the reporter is also dealing with other appeal cases that do have ministerial targets. The temptation would always be, well, I'm going to put that big case to the side for a week till I get this case or these cases away. So yeah, we're just we've been instilling a bit of rigour around that, and supporting reporters to meet those targets, and that's really bearing fruit so far. We're recording a really significant quickening of how long we're producing reports in those cases. And I'll come back to that later, just thinking about our resources and what might be coming our way. So yeah, all of that work's going on. You can see what we've said on that in Guidance Note 23, which is published on our website, like our other notes. As far as help from the parties to help us achieve that, well, all I would say is front load your case. That's what is expected if everyone concentrate on the essentials. And I would make a plea along the less is more route. We often are faced with hundreds of documents and cases, and you sometimes struggle to wonder why all of those documents have been submitted, but the reporter will have to read them. I'm not saying read them from cover to back, but we'll need to make sure that there isn't anything lurking in those, that something that ostensibly might look not that relevant. You want to make sure that you've got the comfort that you aren't missing something. So yeah, I would say really concentrate on the essentials of your case and forget about all of the peripherals around it, because they aren't going to sway the decision or the recommendation one way or the other, are they?
Yeah, I think that comes from being told that, you know, if you have to lodge everything, and that, you know, if it's not lodged, you know, because before we used to have core documents and, you know, libraries, and now it's like, no, you also need to lodge, if you're referring to the plan, you know, you need to lodge the plan. So it's like, yeah, I would be guilty of one of those. If I mention a document, I better put it in just in case you don't have a count of it. So yeah, so I'm probably guilty. I'm guilty of that. So still looking at timescales, and as you say, front loading everything. But one of the things that I've noticed is we get far more further information requests, you know, on appeals. So we've put everything in, but the reporter then comes back and asks for more information. It's 14 days for me to respond and 14 days for the other side to respond to my response. And that seems to kind of slow it down. I suppose, is there any guidance given to reporters on when to issue a further information request, and when that might have been the time to say, actually, let's have a hearing, or let's have a wee online session that might be able to deal with that quicker?
Yeah, there is guidance note 8. I'm referring extensively to our suite of guidance notes, but that's a reporter's guidance note just on further procedure in appeal cases. You know, what route should you go down and when should you do it, and so on. So yeah, that's all published and is there. It's really timely that you've asked that question, though, because it's something that we have been thinking about ourselves. Our performance on further written submission cases used to be very good, better in fact than our performance on site inspection cases, because the further written submission request kicks the target date from 12 weeks out to 20 weeks. So it used to be very easy to hit that target off late, and probably more than a year or two. We've had a developing issue of dipping performance against targets on further written submissions. So it's something I've been thinking about for a while. Every month we look at our performance against target and the different work streams, and we have been looking at all of those further written submission cases just to see what's been going on. I spoke to the Law Society Planning Committee. Is that the right name?
Yes.
Planning Committee.
Yes.
And they raised this question also, and very much along the lines of, you know, if you've had 3 sets of further written submissions and you're still not quite there, wouldn't it have been quicker to have had a hearing on this? So we have kicked off a short life working group within DPA to look at that. So we're analysing trends. Just thinking about the last 5 years or so of appeals regulation cases, 5 years or so ago, about 35% of our cases would have gone through further written submissions. That's up to about 55% now. So it's more likely that you'll have further written submissions than a site inspection case for an appeals regs case, which, you know, in the context of a front-loaded system, doesn't feel right to me. So yeah, we're looking at that on a number of strands. Are these requests necessary? You know, are we sometimes turning over stones that don't need to be looked under? Would a hearing have been better? And you know, we've always said once you get onto your third further written submission request, you know you should have had a hearing, but it's sort of a lost leader by that time, isn't it? It's sort of one final push.
You're there before you know it.
Yeah, absolutely. So yeah, we're looking at all of that, and I think the output of that work that's underway at the minute is that we're likely to publish a refresh guidance note 8, which will just give a bit more advice on when a hearing might be more appropriate than a further written submission request, when a further written submission request might not actually be required anyway. And you know, when we're in the world of virtual hearings, it's much easier to do that now than it would have been in the past. And yeah, absolutely get the point that in the end, in some cases, it might well have been quicker just to have a short, sharp virtual hearing than have further written submissions rolling on for weeks and weeks.
Yeah.
Just on that, Scott, actually, we've had a question that is quite pertinent at this point, and that is that reporters will in many cases have to consider and form opinions on technical subjects, which I imagine is often covered by your request for further written submissions. During the assessment of appeal, the technical issues will arise, and often reporters will have to consider conflicting opinions put to them by opposing parties. In many, probably the majority of cases, reporters are unlikely to have the technical or professional expertise to adjudicate on such matters like noise, odour, flooding, etc. In such cases, does DP engage the services of relevant professionals to assist reporters in forming judgments?
The answer to that is no. We don't. I think there's isn't there a provision in the Planning Act that allows us to appoint assessors in some cases, and I think it's years since we've done it. The one that springs to mind was the Bewley-Denny overhead line inquiry, where I think an assessor was appointed to assist the reporters. I think he must have been an expert in overhead lines. I'm not sure which aspect of them, but yeah, I mean, it's fair to say that reporters are jacks of all trades. You know, they all come to the job with different backgrounds. Most are planners, but we have engineers, architects, lawyers, and various other environmental science experts and so on. But yeah, we would pretty much expect any reporter to be able to take on any type of case, although we do obviously know which reporters are stronger on which case types, and tend to try and allocate it in that way. You know, I would say that the reporter, and it's important that the reporter doesn't bring their own evidence to the case. So, you know, a reporter coming along to a hearing on noise, for example, shouldn't be sitting there thinking, well, I know more about this than both your noise experts, and I think they're both wrong anyway, and I'm going to reach my own conclusion on that. You know, the reporter's there to either take the evidence that's put in writing, or to listen and probe evidence at a hearing or inquiry. Obviously, that evidence is good to be led in a way that a non-specialist reporter will be able to understand the points that are being made and reach a reasonable decision on that.
I think that's always, I always say to, you know, my team, it's like, because lawyers are often in the same position, you know, we've got to deal with lots of different technical, and it's like, you have to explain it to me, you know, I am the woman in the street, and because that's how you're then going to get it across, you know, kind of to the reporter. I suppose that following on that, are reporters encouraged to keep up with, I suppose, kind of market changes? You know, do you do CPD training? Alistair Edwards was at the RTPI conference recently, and I saw him there, and he'll have heard me kind of giving the planners that were there, so you know, you need to be out in the market, knowing what the market is doing to be able to be determining, you know, kind of planning applications. So I suppose, what do you encourage reporters to do? Because we've got different types of development coming out, the technology, as Victoria mentioned. How do you guys keep up to date?
Well, I suppose we do similar to what folk in the profession will do, and that is that, you know, we all do our own reading and sort of topic-based learning and so on. We all have personal learning plans in Scottish Government, and those are updated every 6 months. So that's a sort of continual process. I suppose I go back to the point that I made just a bit earlier, and that is that reporters need to consider the evidence presented to them in each case. You know, they can't import their own evidence. So, you know, salient points about how the market in the build-to-rent sector works, if that's critical to a decision, you know, that needs to be spelt out to the reporter in the case. But yeah, I mean, it is beneficial to have a background knowledge and understanding of different sectors and commercial drivers. So, you know, to try and keep us up to speed on that, we have monthly reporter seminars. So we'll try to cover topical issues, you know, often things around housing land supply, different renewables technologies, issues around renewables like noise and aviation radar and aviation lighting and so on. So we'll often have possibly a reporter or reporters who have worked on a certain case will talk about that, talk about the issues that it raised. But we also bring in, folk from the key agencies and from our stakeholder working group. So folk like CPA and SNH and HES and even Homes for Scotland, renewables, Scottish renewables rather. We bring them in and they all speak to us and just to try and help and assist with our sort of background knowledge of topical issues. We've started having at our seminars an open mic session, which has been really fruitful actually, where reporters will just as the name suggests, come and do a half hour or so on a novel case type or an interesting issue that's arisen, and that really helps to share the knowledge around the cohort of reporters. So that's what I'd say. A lot of learning activity goes on, but whilst that's useful background, we can't import that into a case, so it needs to be spelt out for us in each case.
Yeah, I was just about to ask you what your favourite karaoke song was, if it was kind of open mic.
I did it my way.
You mentioned obviously that some reporters are just kind of on the same theme, but some reporters obviously are more have got more experience of certain types. Do you try to keep or give Section 36 ones to certain reporters, or do you get a whole widespread? If I'm a reporter, I could get anything. I could get anything from my animals to my wind farm.
A bit of both actually. Obviously that the experience of the reporter, how fresh in the door they are, will dictate the types of cases that they're given. Where we would never expect a newly appointed reporter to disappear off and do a Section 36 inquiry, for example. I think we'd never see them again. So there's training and mentoring goes on at that stage. But yeah, we would hope and expect that most reporters would in time be able and willing to take on most case types. As with everyone else, though, there are some issues that some of us might find easier than others do. There are some reporters who will prefer appeal casework to LDP examinations, for example, and vice versa, just depending on their background. So we try to make sure that they all get a broad range of cases, because that often provides a bit of challenge, doesn't it? When I came in from a development management background, I was happy as Larry dealing with appeal casework, and I was a bit daunted when I was put onto my first LDP examination. But it stretches you and challenges you, and so yeah, we do try to do that. And we in those monthly returns that I spoke about before, there's a little box at the bottom where we ask the reporters to let us know, is there any type of casework they would like? In terms of broadening their experience, is there anything that they absolutely don't want again? Someone that's came off a Section 36 inquiry often doesn't want to go straight back onto another one. So we take all of those factors into account.
You mentioned LDPs there. Obviously, with the delays in NPF4, we've got a lot of LDPs that are now out of date, and we've been waiting for the new LDP regs to come out. It feels as if all the local authorities are going to be embarking on the review of the LDPs all at the same time, which means that they're all going to come to you potentially, at the same time, and we've got to throw in the gate check and the examinations, I suppose. So how have you been preparing, or how do you think you're going to cope with that going forward?
Well, we will cope with it. You always have to cope with these things, don't you? But yeah, we've been doing a bit of work with planning division on preparing for that. So, for example, we had I think it was Alison Corb, now one of our assistant chiefs. She participated in the Murray gate check pilot. So there was good learning from that we've since discussed with planning division. We all obviously, as you would anticipate, speak to planning division about draft regulations and guidance. And once NPF4 is laid before Parliament again, we'll be sort of, I would imagine, upping the intensity of our work with planning division on the development planning side, just getting ready for that raft of gate checks and examinations. And yeah, you're absolutely right to say we're going to be, I mean, every authority doesn't move at the same pace, do they? So we know that although there'll be a sort of lump coming our way, it'll taper in each direction. So we're feeding that into sort of business planning process at the minute. Sadly for us, though, that's coinciding with what we think will be, and what energy consents tell us will be, a really significant uplift in onshore wind farm activity. So, both case types need really experienced reporters to lead them, and both are really resource intensive from a reporter perspective. So we've been doing a lot of work. Well, what I mentioned around guidance note 23 and a more efficient process was one of the triggers for that was anticipating what's coming down the tracks over the next 5 years or so. So yeah, we're trying to forecast as well as we can. We've got good engagement on the LDP side with planning authorities, so we speak to them all on a maybe a 3-monthly basis, just asking what's your prediction as to submission for examination, and obviously we step up our work with them as the expected submission date gets closer. So yeah. But my plea to planning authorities, and most are really good at this, would be, we know things go wrong once you've been at committee or before you get to committee, but try and be as open and accurate with those predictions, because when we think a plan, a big city plan, for example, with lots of representations on it, when we think it's coming in a couple of months' time, we'll start to think about allocating a reporter to that, and it can get frustrating if that time scale falls back 3 or 4 months, and then we've got a reporter hanging around that we need to then get onto some other casework. So yeah, just getting that prediction of the pipeline as accurate as we can would really help us. And yeah, I suppose the other thing to bring into the mix on that is budgets, which I sort of referred to earlier. It won't be surprising for anyone to hear that we, like all divisions in SG, are being asked to model various savings scenarios, if you like. We've got not a recruitment freeze, but we've got recruitment controls in place at the minute. So we need to get Director General sign-off, even if just filling a post that's become vacant. So that's quite a stringent process. Over 90% of our budget goes out on staff costs and self-employed reporters' fees. So it's hard to see where significant savings would be made. So, there's no outcome to that process yet. And I don't want to send balloons up, but that's going on at the minute. And in the past, our reaction to significantly increasing case workflows would be, well, we need more reporters. Yeah. I think all I'm saying at the minute is, and more caseworkers come to that. I think what I'm saying at the minute is that can't be guaranteed in the situation that we all find ourselves in at the minute. So. Yeah, that's in the mix as well.
Yeah, because it's not unusual to have, for an LDP to have 6 or 7 reporters, on it, depending obviously the number of objections, and there'll be certain authorities have more objections, more unresolved objections, than others. I sat with Alison, sat also on the Scottish Government working group with me. I was on that for the gate check. And that was interesting because it covered everything, from the planning authority to, I was on for Homes for Scotland, the reporters, the stakeholders, Scottish Gas and Transport Scotland, all that. all trying to find out, well, what is the best way? How much information is enough? You know, and that was what Alison was saying. I kind of, you know, you kind of need to know what I'm measuring it against to be able to know. We had a big debate, you know, in terms of not having the detail, not running an LDP examination twice. You know,
well, that's exactly it. You know, I don't want a gate check and an examination to equal two examinations, because you can, it's not proportionate. And you think of the resources not only for us but for everyone else in the process. So yeah, we will be doing some, you know, informed by things like the Murray pilot, we'll be doing some serious thinking with planning division about how all of that might work.
Yeah, I'm conscious of time, and Victoria, look at me. I've got a couple of last questions to kind of throw at you. So one of them is, I seem to remember back in the day that all the kind of reporters used to get together on a Friday, I think, and kind of have lunch and have a chat. I just wondered, in terms of precedent and discussion of, you know, if you've got a planning appeal, before the decision letter goes out, is there a possible discussion? Does it get run by you? Does it get run by legal? Just kind of looking. I often think, one of the, back to the bit about mystique, the bit thing is, I always thought being a reporter must be quite lonely, because I used to see reporters out inquiries and they had to have lunch on their own, and I just sit on their own. It's like, oh goodness. You know, is there actually much more collaboration than we think, than we see?
Yeah, there is, and a lot goes on behind the scenes. I think says he's sitting in his lonely home office at the minute. But yeah, yeah, there is. I think the important thing to say though is that whilst reporters will talk about topics and case types, you know, they're the appointed person. They're the person appointed by ministers to make a decision or a recommendation. So, you know, when we've got, you know, particularly contentious issues, and things change over time. You know, for example, at the minute, it won't surprise you to hear that housing land supply casework is vexing us, vexing everyone at the minute. So we've got a system in place where if there are any cases turning on the reporter's findings on land supply, that will be read either by me or by an assistant chief before it goes out. And you know, really important to say again, that's not a case of us substituting our planning judgment or reasoning for that of the appointed reporter. It's to try as far as we can to ensure consistency in decision making, because although each reporter is appointed personally to each case, they're making decisions on behalf of ministers, and I think it's only fair that stakeholders can expect a bit of consistency in decision making. It might not always look like that, but yeah, we try to ensure as far as we can, bearing in mind though that the nature and quality of evidence can vary vastly from case to case. So, you know, it's difficult for a reporter in a council area where you know, indifferent evidence as to housing land supply has been put before them. They know what's going on in other decisions, and you'll sometimes find yourself thinking, that can't be right. And I know what's been said in other appeal casework, and you know that might be a factor that's feeding into this rise in further written submission requests, where the reporter's thinking, that's not right, I don't think, and trying to get more or different or better quality evidence. But there's a limit to what the reporter can do on that.
It makes me laugh, because it makes me think of inquiries where you would, you know, think that your witness, if you like, had escaped because the cross-examination had been fairly gentle on the questions, I think, and then the reporter would come in with the questions. It's just this bit of, well, but actually this, and this, you know, and that often you felt that actually perhaps that the other side hadn't necessarily put the case forward, you know, very well, but the reporter knew exactly, and then all these kind of questions kind of came in. So so yeah, that I'm campaigning obviously to get lots of inquiries back, and you know, six-month LDP examinations. My final question was just, I suppose you've now kind of just been in post since July. You've got budget cuts, you've got all of those. Have you got any key aspirations, you know, for the next kind of 3 years? Where do you want to be?
Yeah, I suppose just thinking back to what Victoria said at the start about mystique, I want to get us away from that, really. I want to demystify the process, and I think we already operate in a really open way. You know, we publish everything that we do, and that isn't the case in every jurisdiction, and wasn't always the case for us. We're always very open to speaking to stakeholders about various issues or topics or case types. So yeah, I want to sort of ramp that activity up, if you like. I suppose overall, I want to try and maintain quality and efficiency in decision making. And thinking about, you know, what we're faced with increased case flows and potentially reduced budgets, just thinking about efficiency, specifically on sort of hear and report cases like wind farm cases, specifically on LDP examinations. Because you're thinking about those examinations, the aspiration always was for a light touch examination, and you know, you could say that over time that's maybe sort of increased in the numbers and the length of time and the cost, which is a really important consideration for the planning authority. So I want to do some more work around that. And yeah, I think if I can manage to do all of that, I'll be quite happy at the end of 3 years.
You're certainly going to be a busy 3 years. I think we can safely say that. Like,
just one other thing
yep.
to mention. You asked about the reporters meeting pubs and things like that, and of course they're human. But just to mention that last month we were out on an axe throwing evening, so that really enjoyable team building event, and one of the reporters, who will remain nameless, scored better personally than my team of 6 scored cumulatively. So there's a reporter out there that you definitely don't want to mess with.
I definitely don't want to mess. That's right. Oh, that's great. Victoria, I'm conscious of time, and as I say, Scott and I could probably chat all afternoon. So
yes, I know, and I was just thinking the axe throwing goes some way to demystifying and removing any residual mystique that was left, Scott. So I think that's an appropriate point to
maybe
finish.
Maybe I should have mentioned that.
It probably remove limbs as well.
Yes. Be careful on site visits. Thank you everyone for joining us this afternoon, and of course special thank you to Scott for sharing all of his thoughts and experiences with us. Today was about planning appeals, but what happens if you don't like the reporter's decision on your appeal? Well, you had better join us for our next Planning Live session, which will take place on the 24th of November, when we will be discussing the practical aspects of judicial review and statutory appeals of planning decisions with Neil McLean, who is a solicitor advocate as well as a partner at Brodie's and a member of our advocacy team. You can sign up for that session now or watch out for our reminders nearer to the date. Thank you again to everyone for joining us this afternoon. Bye-bye.
Bye.
Thanks.
Bye.